So the Supreme Court's decision in New York State Rifle and Pistol Association v. Bruen is now impacting the California case, challenging the state's restrictions on how many handguns and rifles someone can purchase in a single month. So let's talk about this. But real quick before we jump into this video, if you think the state of California restricting how many firearms you can purchase in a single month is unconstitutional, go ahead and hit that like button and subscribe. Also, I want to give a shout out to one of the main supporters of this channel, which is USCCA. Through your membership, you get training, education, and self-defense liability protection. So if you carry a firearm, I highly recommend you take a look into USCCA, and I'll put a link to them down in the details section. So like I said in the intro, in reaction to the Supreme Court's recent ruling in New York State Rifle and Pistol Association v. Bruen, the district court in the Nguyen v. Bonta case has now requested additional briefings for how the judge should now decide the case in light of Bruen. This case, Nguyen v. Bonta, is filed and led by Firearms Policy Coalition, and actually was one of the first cases I helped get filed when I was originally with FPC. This case challenges the new California law, which prevents California residents from being able to purchase more than one handgun or semi-automatic centerfire rifle within the same 30-day period. Last July, a new law went into effect in California, which made it a misdemeanor for someone to purchase a handgun legally through an FFL, and then to also purchase a rifle or another handgun in the same 30-day period. Now, for a while, California under Penal Code Section 27535, subsection A, said that no person shall make an application to purchase more than one handgun within any 30-day period. So California had established a law that an average person, an average resident, could only purchase one handgun in any 30-day period. But as we know, California is never satisfied with their restrictions as they stand. Therefore, a new law was passed last year, which expanded that language from only applying to handguns to now applying to also semi-automatic centerfire rifles. And starting last year on July 1st of 2021, the California's new law stated, a person shall not make an application to purchase more than one handgun or semi-automatic centerfire rifle within any 30-day period. So California law has now shifted so that someone cannot go into a gun store and purchase multiple handguns or purchase multiple semi-automatic centerfire rifles, or which would be ARs or AKs during the single transaction, or even within the same 30-day period. Essentially, you have to wait 30 days and you kind of have to pick and choose which one do you want to take possession of within that 30 days. Do you want to take possession of the handgun, a rifle, but it can't be two of either or a mixture of both. Now, how is the state of California enforcing this? Well, they included in the law that a violation of this law constitutes at a minimum a misdemeanor criminal offense. So it would be a misdemeanor to take possession or to purchase or even maybe even apply for more than one handgun or more than one semi-automatic rifle or a mixture of both within any single 30-day period. Now, of course, this did not sit well with California residents, 2A advocates, and groups like Firearms Policy Coalition, so a lawsuit was filed in the Southern District of California. Now, this lawsuit alleges that the individual plaintiffs in this case are legally able to purchase and possess firearms, including handguns and semi-automatic centerfire rifles, but they are unconstitutionally barred from purchasing more than one in any 30-day period. It is also argued that the state of California had no rationale for barring the purchase of more than one handgun when they originally passed that original law, and even more so, they didn't even have additional rationale or evidence that they needed to expand that law to also apply to semi-automatic centerfire rifles. This law's entire goal is to have a chilling effect on the legal purchase and ownership of firearms within the state of California. The hope is to make it so hard or impossible for people to purchase firearms, make it so time-consuming that maybe people choose to simply not purchase more than one firearm. In this case, both the state of California and Firearms Policy Coalition have filed cross motions for summary judgment, seeking to effectively end this issue now. In simplest terms, a motion for summary judgment is a request made by one party or both parties asking the court to decide all or part of the lawsuit without going to trial, because the claim is that there is no dispute about the key facts and that this case can be resolved right here and now. Now, I'm not going to go in depth on both of the motions for summary judgment by the state of California and FPC, but instead I just want to hit on some of the important key arguments that was made in the FPC motion. FPC argues the 1 in 30 law is in reality just another part of California's bloated regulatory regime that increasingly chokes off the flow of Second Amendment guarantees to its citizens behind a veil of pretextual and untailored claims of pursuing public safety. But even granting the state the greatest benefit of the doubt, they say that plaintiffs are still entitled to a summary judgment because the law is indisputably unconstitutional under even the most lenient standards of scrutiny that could possibly be applied in the favor of the state of California. So in the summary judgment, FPC hits on what was the standard review as established by the Ninth Circuit, which was the two-step approach or the balancing of interests. However, also in the original summary judgment motion, they also hit on the whole text as informed by history being the correct type of standard that should be applied instead of a balancing of interest or the two-step approach that the Ninth Circuit has used in the past. They state, as the pronouncements in Heller make clear, the true test for the constitutionality of restrictions on the Second Amendment right involves a simple, single inquiry. Is the prohibited conduct protected under the scope of the Second Amendment as defined and understood when the people adopted it? If so, then the prohibition is unconstitutional, period. That inquiry would end the analysis here and quickly dismantle the 1 in 30 law at issue, given the clear historical record securing the right of law-abiding people, like plaintiffs, to purchase multiple firearms without any restrictions on the number or frequency of such acquisitions. Simply put, what they are saying there is that there is no long-standing historical basis or support for this type of restriction. Since the formation of our nation, you could purchase multiple firearms at a time and however frequently that you wanted, and that has been the norm in our country since the very founding. This restriction in California is a novel restriction that didn't pop up until 1975 and has since only been tried in a handful of states. 1975 and a few states having similar laws cannot serve as a long-standing historical support for this type of restriction. Now, those motions were out there before the Bruen decision even hit, but now the Bruen decision has been released by the Supreme Court, and as we just saw, the Supreme Court just rejected the two-step approach that the Ninth Circuit has used in the past, and instead they affirmed that text as informed by history is the entire constitutional test. And because of that language there by the Supreme Court, the district court here in Nguyen is requesting supplemental briefing and for both sides to outline what standard now applies to this case and how does this standard apply to resolve the motions for summary judgment. In reality, the FPC motion already outlined that the true Heller test would completely obliterate what the state of California is doing with the 1 in 30 law. So supplemental briefing will now happen in this case, and the state of California under Bruen has the burden to show that their regulation, this 1 in 30 law, is consistent with the nation's historical tradition of firearms regulations. This, of course, will be very hard since, like FPC stated in their original motion, a restriction on how many firearms someone could purchase and how often they could purchase them really didn't even pop up until about 1975 in our nation. That is a far cry away from the 1791 historical analog that is required under Bruen. So this is an interesting case, and this would be a solid win to get rid of California's purchase restrictions. Now, I know some people think that this isn't a big issue, but think about what happens if something like the handgun roster was lifted or the ban on so-called assault weapons is also lifted. I know a lot of people would want to go out and purchase multiple firearms, maybe in a single transaction or maybe within any 30-day period. Well, because of this law in California, you would be barred from purchasing what you wanted at that time. You would have to choose between a handgun or a rifle, and you would only get to pick one or the other. So that is why this law is so sneaky. It drastically limits your ability to purchase what you want when you want it. And they are all doing this under the guise of public interest, which they really didn't put forward any real evidence or basis for why this would actually serve the public interest. But even more so now, under Bruen, the public interest doesn't even matter. The only thing that matters is text as informed by history. I will definitely be keeping my eyes on this case. If you guys have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, like this video and like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet and signals to YouTube that you guys see value in these videos and in this type of two-way news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So again, thank you so much for all of your support. And as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this is with Built by Armed Scholars, and this nation will be maintained by Armed Scholars.